Good morning, everybody. Just about 10 o'clock. We are going to start this meeting of the Judiciary Committee, and we are going to go into recess. Thank you.
Morning. We're going to call this public hearing to a start. We're going to, are there any comments from
Want to wish the commissioner happy.
Senator Kidd?
Thank you very much, Chairman Winfield. I just want to wish Commissioner happy birthday, Mr. Shea, and many more to come.
And because we like you, we will not say. All right. So we'll begin with Alexander Thomas. For folks, you have 3 minutes when you come up, and we'll cut you off at the end of your 3 minutes. So please try to cut yourself off, and we'll see if there are any questions. Mr. Thomas and Mr. Streeter are the first two folks, so we'll begin there. Thank you. You may hit the button in front of you to activate the mic.
Good morning, Senator Winfield, Representative Fazzino, Representative Fishbein, Senator Kissel, and anyone who else is watching. My name is Alexander Taubes. I'm here with my client, Maceo Troy Streeter. I'll be speaking on behalf of both of us, but if you have any questions for Mr. Streeter, he's here to answer any questions you might have. Mr. Streeter spent 23 years in Connecticut prisons for a crime he didn't commit. Just hours after the only person whoever testified that they saw Troy commit this crime had already told the police twice that he hadn't seen Troy, he hadn't seen anyone at the scene. Within hours, one interview with one New Haven police detective changed everything. And that arrest warrant, which omitted the prior non-identifications of Troy, was a pattern that unfortunately existed for a long time in New Haven, Connecticut. Most of America's 16,000 police departments have no record of any wrongful convictions. New Haven, Connecticut's police department, one of the smaller ones, if you go around the country, it's not as big as New York, has 19 on the National Registry of Exonerations. But we're here today to talk about Troy, and I can't put it any better than the well-reasoned, extremely detailed, and thorough decision of Commissioner Shea. Commissioner Shea went through all of the evidence, prosecutor reports, transcripts, police reports, affidavits, deposition transcripts, and live testimony from 3 witnesses at a hearing, and reached the conclusions in the decision he has before you. We support that decision, and we ask you to support that decision as well. Thank you, and I'm happy to answer any questions you may have.
Thank you, Attorney Thomas. Questions or comments from members of the committee? Questions or comments? There are none. We want to thank you for joining us again to provide your testimony.
Thank you very much.
Next, we'll hear from Joyce Gamble.
Okay. Good morning, everyone.
Good morning.
Wait a minute. Go ahead, you can talk right now. Okay. I'm here on the behalf of my son, Terrence Gamble. I don't know the decision what was made about giving Mr. Troy Streeter the money, but I'm here, all what I heard from the last one, that the court turned him down 3 times. Nothing was said about he was innocent. I don't know what else they looked at when question was asked from the lawyer to him. There was some faults in there. There were some lies in there. Okay, when Mr. Reverend Kimball got up there, Mr. Troy Streeter had said that he hadn't talked to Reverend Kimball. When Reverend Kimball got up there, he said he had talked to Troy Streeter. So the lies are being told. I don't know what the decision is about this money, but if whatever decision is, I'm just going to say, if the decision is for him or not for him, if it's not for him, I say the system is justified. But if the system is for him, I was saying, where is the justice? That's just like you giving money to a person that's guilty and have been found guilty, and people that's the children, lives, the adults that have been killed. What you're saying about that? So what you're saying is that all that person that got killed, the person that shot them is innocent. And here I am, I'm just sitting here, I'm just saying, all I can say is in y'all hands. And whatever decision y'all make, and if y'all, lies is lies. The truth is the truth. And if the system follow for lies, I say it again, where is the justice? And he was, and was proven that he was guilty. That's all I have to say, and y'all have a nice day.
Thank you, Ms. Gamble, and thank you for joining us again to provide us with your testimony. Other questions or comments from members of the committee? Questions or comments? There are none. Again, thank you very much. Next, we'll hear from Zach Levy. Zach Levy. Okay. Commissioner Shea. Commissioner, we are going to make a slight modification since you will probably take more than 5 minutes. We're going to let Ms. Karen Jackson jump in, and then we'll go back to you.
Certainly.
Thank you, sir.
Ma'am, you have your 3 minutes.
Give me a chance to settle in before you start counting minutes.
We're not going to cheat you out of your 3
Okay.
minutes.
Greetings. My name is Karen Jackson. I'm from Montego Bay, Jamaica. I came to New York when I was 11 years old, and I spent high school, junior high school, college. I was a social worker for ACS, which is like DCF here. And then I got married, and my mother said, "Okay, I'll buy you a house in Connecticut." So I had to come here. Not I didn't have to come here, but I came here, and I was what, 34, 35, and I was a domestic violence survivor. I didn't know that at the time, but the ex-husband manipulated my mail through DSS, and I was charged with larceny one, and it was through coercive control, which is now a law. So I was locked up for 22 days because the ex-husband decided to call Bridgeport police and said I missed the court date, which I didn't know about because he manipulated the mail. So I fought for over 20 years. I've been a teacher. I've been a city councilwoman at the city of Bridgeport. I just got a pardon last year. So I filed a claim with the claims commissioner just to find out that it was untimely. But those 22 days in jail, in prison in Niantic, mapped my life and my children's life. I had to live in the ghetto. I had to live amongst people in a racial gerrymandering environment that afflicted my children and myself. And 22 days in Niantic was hell for me. But I'm here, and I wanted to make it clear that there are many people like me who get convicted of crimes that they didn't commit. And that's it. Thank you very much.
Thank you. That's a useful perspective to have. Comment or question from members of the committee? Comment or question? There are none. Commissioner Shea. Welcome back.
Good morning. I'm Robert Shea from the Connecticut Claims Commissioner's Office. If I could just start and let you know, Ms. Jackson had a hearing in our office about a week or so ago with the Attorney General's office, and it looks as though Ms. Jackson potentially has a viable claim under our wrongful incarceration statute 54-102 UU. So we will be scheduling a hearing, Ms. Jackson, as we informed you. So we don't know for sure yet whether Ms. Jackson will be eligible under that statute for the 22 days she was incarcerated, but we are holding a hearing.
Thank you. Comment, question, Rev?
Okay. Yeah,
Representative Fishbaum.
thank you, Mr. Chairman. Good morning, Commissioner Shea.
Good morning, sir.
Did you wanted to say anything? You know, I didn't know whether just to jump in or say anything in support of your recommendation for an award before I jump in. I just want to give you that opportunity.
Well, I just want to thank the committee for allowing our office to take another look at this claim and to go over all of the information relating to what has happened since 1990 with Mr. Streeter. So I'm happy to answer all the questions you may have as to how I got to the decision, which is in this package.
Just before you guys go back and forth, Commissioner, could you either move the mic closer to you or?
I'm sorry about that.
Yeah, thanks.
So thank you. And, you know, most people inside these walls, outside these walls, don't know a lot about this case. So I just want to generally track what we have before us. You know, it appears that in May of 1990, Mr. Streeter was arrested for murder. And there was an investigation that was done by the New Haven Police Department at that time. And there was a trial originally in 1991, and that trial ended up in a hung jury. There was a trial then in 1993, and the result of that trial was that Mr. Streeter was convicted of murder. He was sentenced to 35 years. He ended up serving 23. At that trial, there was no forensic evidence. However, there were 3 witnesses that testified. At least 3 witnesses, we'll say that. Mr. Preston, Ms. Cheeks, and Mr. Donnie Andrews.
Correct.
I got it
correct
so
so
far?
far, yes.
Okay. Shortly thereafter, a couple of years later, Donnie Andrews appears to have recanted his trial testimony.
I would say that his initial recanting was in December of 93, soon after the trial testimony.
Yeah, the trial was in 91.
No, the trial was there was a
sorry.
trial in 93, and my recollection is that Mr. Andrews recanted in December of 93.
You are absolutely correct.
Right.
Yes, thank you. Thank you for that. Why the state's attorney didn't go after Mr. Andrews for lying under oath, I don't believe they did, and I don't know why they didn't. But then there's an appeal of the conviction in 94. And that appeal, Mr. Streeter's appeal is unsuccessful. And then in 98, there's the first habeas application. Now, it appears that in the first habeas application, that the recanting by by Andrews is not raised. Is that true?
If you give me a moment, Representative Fishbein, I'm looking at the text from the 98 habeas decision issued by Judge Downey. I mean, yeah, well, Judge Downey does reference, I'm reading from a text from the habeas decision in 98, which Judge Downey says, at the trial, which culminated in the petitioner's conviction, the witnesses included Carolyn Cheek, Joseph Preston, and Donnie Andrews. The newly discovered evidence alleged by the petitioner consists of statements made subsequently by these witnesses repudiating their testimony. So he does, I think Judge Downey did look at the fact that Mr. Andrews repudiated his testimony. At least he says that in his decision.
Well, I have to say, it's unclear to me.
Fair
Because
enough,
he
yeah.
certainly doesn't say Andrews, he doesn't say Andrews recanted, right?
Well, here's what he does go on to say. Cheeks purportedly signed an affidavit to this effect on or about October 23, 1993. Andrews signed an affidavit on December 8th, 1993, stating he lied at trial. So Judge Downey puts that in the 98 habeas decision. So he respectfully, I think he does mention Mr. Andrews' repudiation.
Okay. And do you know why Judge Downey says Cheeks purportedly signed an affidavit?
I don't know why he said purportedly.
So purportedly would usually mean to me that
For the
somebody,
purpose of signing an affidavit, right?
Well,
yeah.
you know, at a habeas proceeding, witnesses testify, right? We have references now to affidavits. We have a judge of the Superior Court holding a habeas trial of sorts and chooses to use the term purportedly. So that would mean to me that somebody is represented to the court that Cheeks had signed an affidavit. However, that affidavit was never presented. That's my take on that. I couldn't glean that from the decision. But I'm also
That's a fair point. Yeah.
I also note that, you know, the court is the arbiter of the reader of the witness, right? It's impossible to read the witness when you're looking at a piece of paper. So my take on this is that Andrews didn't testify before the habeas court either, correct? Because Judge Downey didn't say.
He's talking mostly about Mr. Preston's testimony. You're right.
Yeah. So we got three witnesses. You got Cheeks, Preston, and Andrews. Cheeks purportedly signed an affidavit, so it wasn't presented to the court. I think we can reasonably presume that. Andrews didn't show up for the habeas trial, so he didn't testify. So Judge Downey didn't get to determine his credibility. And Preston gave a taped statement. He wasn't in court either, right? That's the takeaway on the Downey habeas trial.
So yeah, what Judge Downey did, I'm just looking at my decision, Rep. Fishbein. He does state that he looked at the transcript from 93 about Gamble's, Mr. Andrews' testimony. And what Judge Downey says is that was why he had testified that the petitioner shot Gamble. A review of the trial transcript, however, reveals that Andrews did not testify he saw the petitioner shoot Gamble. Andrews, in stoutly maintaining he testified falsely that he witnessed the petitioner shoot Gamble, undermined his own credibility. His testimony was loose, equivocal, and contradictory, and ultimately unpersuasive. So Judge Downey did look at the trial transcript from the 93 conviction.
Understood, but
Yeah.
I don't know, Commissioner, if you ever reviewed a transcript of a court or a hearing proceeding? I'm sure you have.
Well, have I ever in the last
Right?
in the last 3 years? Yes, I
Yeah.
have. Yes.
And I don't think I've ever seen one that I didn't like. Did I really say that, or I say it that way? No,
Well, that's why video transcripts are better, actually. Yeah.
absolutely.
Yeah, they are better.
Because
I
you
agree.
can see how the witness is answering, how they react. Looking at a piece of paper does not assess the credibility of the witness. But you would agree with me that at the habeas trial, based upon Judge Downey's decision and what we're able to discern from that none of these three allegedly recanting witnesses appeared to testify.
I think Mr. Preston did appear.
I think it was a review of a recording. It says Joseph Preston gave a taped statement. Shakespeare, yeah.
Did appear.
Cheeks
So I'm
failed
just
to-
I'm looking again at Judge Downey's decision. It says, at the time of the habeas hearing, Preston testified he had witnessed Terrence Gamble being shot and killed, that at the time he believed that the petitioner was the shooter, but now he wasn't sure, wasn't 100% sure. was doubting his own testimony, did not find himself a credible witness, couldn't say whether the petitioner did or didn't do it. Preston stated he hadn't had enough time at the time of the habeas hearing to look back on the whole case. When asked which was the truth, his trial testimony or his habeas testimony, he answered, I don't know. So I think I read that, Rep. Fishbein, that he did testify at the habeas hearing.
Okay, no, I'll take that. But Carolyn Cheek certainly didn't. She failed to appear. The one who purportedly signed an affidavit.
Yeah, I can't, Judge Downey doesn't really say whether or not she was at the hearing, or at least I can't see it.
Well, in your decision, I know you've corrected me a few times. I'm just gonna, on page 8, the second full paragraph.
Yeah, right, yeah.
Yeah, no, this is an exchange. At the time of the habeas hearing, Carolyn Cheeks failed to appear. So,
Oh, okay, fair enough.
no problem. But ultimately, Judge Downey says that
Oh, but it says Andrews and Preston did appear.
yeah, no,
Fair enough.
we read
Okay,
that
yep.
before. Yep. Judge Downey says the standard here is clear and convincing, and says it doesn't rise to that level and does not grant the habeas petition. That's the disposition.
And the standard is actual innocence, which is a different standard than the wrongful incarceration standard of.
Oh, I don't disagree.
Right, okay,
Yeah, no, we haven't gotten there yet.
okay.
2011, we have another habeas proceeding, and that is unsuccessful. In 2013, we have the appellate court appeals that unsuccessful habeas, and that appeal is unsuccessful. Mr. Streeter serves the 23 years. He gets the pardon in 2022. We have this whole thing with, I don't disagree that there are allegations substantiated in other cases involving malfeasance by New Haven police. One policeman in particular was involved in this case and had some troubles in other cases.
I believe it's 2, actually.
2,
2 New Haven.
yeah, 2. I've been going back and forth about that, whether or not the malfeasance, though, is tied to both. But I think we can reasonably say that at least one, there were some issues with. Whether or not those issues extend to this case, I don't know, but I tend to think more than likely. So then we get to the application for a wrongful incarceration award. That's an appropriate timeline as to where we've gotten? I didn't miss anything.
Yeah,
in the
Mr. Streeter was pardoned in 2022,
I
and
said that.
I believe he filed his application with our office in 2024.
Okay,
Within the 2-year period, yes.
sure.
February 14th, 2024.
So then you, looking at the papers, determined that he's entitled to the award to do the calculation. The matter comes to us. We ask you about your independent investigation as to the grounds consistent with evidence. You pull it back, do a re-review, and
Yeah.
we're back here again.
Yes, sir.
That's basically.
That's the process.
Just for
yes.
the general public, that's where we are,
Yeah.
right? So after you pulled it back, well, let me start with this. I'm in a weird place here because I had a position before on this based upon the work that was done. You had already rendered a decision, and it's sort of like, procedurally, it's sort of like the trial court pulling back and asking for more information, although it's already rendered a decision. So I guess my first question is procedurally, why wouldn't you assign the re-review to somebody else in your office?
I respectfully, I don't have an answer for that, only because I had already put a lot of work into it. I figured I should continue the job.
Okay. Can you understand when my colleagues say to me that you had already come to a conclusion? You take it back, you put the puzzle pieces together and come up with the same conclusion, which makes,
Well, I think I can give you shed some light on that. My prior conclusion was based almost exclusively on the granting of the pardon, based on my reading of the statute, which I now recognize and respect the committee's position that that wasn't enough. The granting of a pardon was not enough to find Mr. Streeter eligible, and I had to look more deeply into the potential grounds consistent with innocence. So that is what I did. So I didn't do my job appropriately the first time around. And I think the committee was sort of suggesting that to me, and I respect that. So I wanted to do my job correctly the second time around.
so how do I address the question that's been addressed to me about procedurally you coming up with a conclusion, coming to an understanding that perhaps that procedure was not the proper procedure, pulling it back, putting the puzzle pieces together and coming to the same conclusion that that is a fair and just process when you could have assigned it to somebody else in your office.
Good point. I just looked at it similar to a remand where higher courts, and you're the higher court here, sends things back for further review.
Well, on a remand, though, in my experience, a remand is with direction to do something, right? So the appellate court finds that the trial court was perhaps wrong in the remedy and remands back to the court, which has the power. The appellate court doesn't have the power to issue a remedy. The superior court does, right? So, but on a remand, because I have a case we just tried 3 weeks ago on remand from the Supreme Court, and a different judge heard it. So that's my experience, is that you don't want the things that, because let's just say it was an evidentiary issue that the trial court originally heard, went to the appellate court, and, appellate court found, well, that evidence shouldn't have come in. You ain't sending that case back to that same judge, right? So on a remand, really for a pure process, I think somebody else should have been doing this. I think it would have given you some cover, quite frankly.
Fair enough. But I thought that, I got the strong message from this committee. I believe I was here on February 27th that I didn't do my job correctly, and I respect that. And I felt like it was important for me to try to do my job correctly and look at all this stuff. So I didn't even think, Representative, that it should be someone else doing my job for me, respectfully. So that's why I handled it.
No, I appreciate it. And I don't want to.
That's my honest answer.
But there is a level of perception that the desire was to come to the same conclusion. So, well, I'll go on.
I had another one that I didn't come to the same conclusion, which is down the road. So I feel very confidently now that where I didn't on February 27th, I feel very confidently that I've done my job in both of those claims that I took back.
Okay. So when you did take the matter back, did you hold a hearing or did you review documents?
We held an evidentiary hearing.
Okay. And at that hearing, did Cheeks, Preston, or Andrews testify?
They did not.
Okay. So Did you try to get them to testify?
I generally don't, at least in my 3 years at this job, I don't tell the litigants who they should bring to testify. So I did not formally say you have to bring these people in.
Why, what, is there, I mean,
I just, like I said, Representative, I don't do that. I allow the litigants to bring in the testimony, the evidence that they want.
so if the gentleman is convicted on the testimony of Cheeks, Andrews, and Preston, then I can only assume that your reliance on their recanting is solely based upon what was presented at the habeas in 98.
Additionally, there was a statement under oath by Mr. Preston in 2024, and I believe a pending lawsuit in New Haven where he says under oath that Mr. Streeter was innocent. So that was something I looked at as well, and I put that in my decision.
So if I was in your shoes, quite frankly, I would want Preston before me, and I would want to ask Mr. Preston whether or not there's any deal for him to share in $5.7 million. I would want to ask him that question. You know, because you're the trier of whether or not these people are telling the truth. There's nothing to stop that from happening here. There's nothing to stop, I mean, any of these guys from sharing. $5.7 million is a lot of money. I mean, to a lot of people. I mean, we got the Gamble family that's sitting there saying, don't do this. And I'm very concerned about that whole portion of this, because if I was trying this, I would not be able to come to the conclusion without looking those people in the eye and reading them. I mean, I read people every day, but that was the choice that you made. The standard here.
Well,
though,
respectfully with Mr. Preston, I thought, and I put it at the beginning of my decision, the way that the arrest warrant affidavit was done, I thought was important, that Mr. Preston, on the first two discussions he had with the New Haven police, said he did not see Mr. Streeter. And then the next day, with a police officer who has, his conduct has since been strongly challenged by the state's attorney's office, says that Mr. Preston said that he did see Streeter. So that it started way back in 1990. You know, the Claims Commissioner's office concerns with the level of the reliability of Mr. Preston's testimony.
I don't disagree, but ultimately what we have before us is I'm paying for this. I lived in New Haven years ago. I wasn't a police officer. Why should my constituents pay for malfeasance by the New Haven Police Department? I know the statute is written the way it is, but ultimately at the end of the day, you know, they created this situation. If that, I mean, because there's other pieces here also, but you know, I understand. Ultimately though, the standard here is whether or not, and we're looking at the statute, which we've said a few times, 54102 UU. The sole area is grounds consistent with innocence, right? That's where we've been focused. And the statute says includes but is not limited to a situation in which a conviction was vacated or reversed and there is substantial evidence of innocence, whether such evidence was available at the time of the investigation or trial or is newly discovered. So to me, that's like clear and convincing. I mean, it's certainly not preponderance, it's substantial evidence. So can you just explain, well, you do cite a case. It's a probate case, though. It's not a criminal case. It's not a civil case. In which the appellate court talks about, says the goal of our analysis is simply to decide whether the trial court's conclusion was reasonable. Using this standard, and that's the substantial evidence standard, and this is where the probate court comes into play. We will give deference to the probate court's determination of the credibility of witnesses and its factual determinations. So once again, we're back to the credibility of the witnesses, but none of the three recanting witnesses testified before you. So you're unable to ascertain their credibility, whereas the courts did rely upon their credibility. So can you just unpack that to get to how you determined substantial evidence of innocence here?
Certainly, Representative Fishbein. Starting on page 16 of my decision, I list 16 items that I feel together make up substantial evidence of innocence.
Okay.
Including the questionable sort of testimony of those three individuals, Mr. Preston, Ms. Cheeks, and Mr. Andrews.
Okay, so number one, because when you just say, well, there's 16 reasons, is somebody, hearing that, whoa, wow. But number one is Mr. Streeter's declaration of innocence during his April 6, 2022 Connecticut Board of Pardons and Paroles hearing. Okay. I mean, how is that substantial evidence of innocence?
Well, I'm sorry if I gave that I might have given the impression that each one of these 16 was substantial evidence of innocence. I think together these 16 items to our office, to me, comprise substantial evidence of innocence. That's
Okay.
one of the 16.
Okay, well, let's read number two. Number two is Mr. Streeter's declaration of innocence during the March 24, 2026 Claims Commissioner's Office hearing. That's no different than the statement in 2022. I mean, is there a particular one of these 16 that you rely upon?
Actually, respectfully, no, not the particular one of these 16. It's a combination of items of evidence that had me feel comfortable coming to this conclusion.
Did Dr. Reverend Kimber testified at the original trial?
Yes, sir.
And he testified that he was with Streeter at the time, and that Streeter, because he was with Streeter somewhere else, that he couldn't have committed the crime. Is that what the testimony is?
I'm summarizing what I believe is generally Reverend Dr. Kimber's testimony, which was that Mr. Streeter visited Reverend Dr. Kimber's church on the evening of May 8th, 1990.
And that therefore he couldn't have been at the scene of the crime.
That was his testimony, yeah.
Okay. And he testified at trial. Obviously, the jury didn't find that testimony to be credible because they convicted Mr. Streeter, because that would be, I mean, if they had a photograph of Streeter there, right, or video at the time the murder's happening across town, that would be pretty compelling evidence. The jury would probably, they'd probably fine for Mr. Streeter. But obviously, the jury didn't find that testimony to be credible because they convicted Mr. Streeter. You would agree with me?
I don't know if I would have it be that sort of conclusory. I mean, there was other people that testified at the 93 trial. So in and of itself, maybe they didn't find Reverend Dr. Kimball's testimony to be enough to acquit.
Okay, but if he had proven it, said, I got a photograph or something like that, or, nobody else testified that Streeter was with Reverend Kimber at the church, right?
That I don't know, Representative
Okay.
Fishbein.
But then once again, when I look at your 16 things, number 4 is the Reverend Dr. Kimber's testimony during the March 24, 2026 Claims Commissioner's Office hearing. I would think that that would have been the same testimony that he gave at the original trial, correct?
True. And again, it was helpful to me that these folks, were under oath before our office, and they testified under oath to what they recall from that evening.
Okay. And,
And that was literally a month ago today, I think. Yeah. March 24th, right?
I sit in a difficult place, right? And I don't want to.
So do I.
Well, yours is a little easier than mine, though, because I got to get elected. But anyway,
I have to get appointed by the Judiciary Committee, which
yeah, but
sometimes
your term is longer than mine. Anyway, I don't want to besmirch anyone's reputation. It's not my intent. But I have to ask the question once again. During the proceeding, you're having a
By the
hearing.
way, I'm happy to answer all these questions.
No, it's not directed at
This
you.
process is really important, so I don't feel like if I'm joking with you that this is important that we go through this process. And I appreciate coming before this committee to answer questions about all of our decisions. So please, yeah, I want you to understand that, Rep. Fishbein.
I don't think anything different, and it
Okay.
wasn't about you, okay? But I'm just concerned about the amount of money, the motivations to say things here. And you as the trier of fact, essentially, of this proceeding, did you have the opportunity to ask other witnesses that showed up at this hearing whether or not they anticipated or had any deal to partake in any of the profit from what was going to be result from these proceedings?
I certainly had that opportunity. I ask a lot of questions at our hearings. They're very informal, but I saw no reason to ask those questions respectfully. I had no feeling that there was anything untoward going on at all. I didn't even think of asking any of those questions.
The Attorney General's office was there,
Yes,
cross-examined the witnesses,
yes,
and had that opportunity to ask that question?
yes.
Okay, I just
And I
want to
don't
make sure.
I don't want to say they didn't ask it, but I don't recall it being asked, to be honest with you.
Well, I'm sure if they did, and
I would have recalled it, but I don't want to, in case you look at the video and say, wait, they did ask. I just don't recall that.
Yeah, I just, because that's another thing that I'm hearing. So I just need to close that door because I wasn't there.
Right.
And certainly if I was on the other side of this case, many times you go after bias of a witness, why you're saying something. So I'm just looking for a pure system. I think those are all the questions that I had. So I thank you for coming here today, and
Thank you for the good questions, and thanks for the support of our office. I wonder if I could just put in a pitch for our office. There are several claims resolutions on the House calendar and the Senate calendar, and our office would be grateful if they could be called for a vote this session so that we can keep decisions and claims moving forward.
I can assure you that if the House stopped going after homeschoolers, we probably could have done that yesterday. So thank you.
Okay, so
Thank you.
you're doing it Monday?
We intend to get those done.
That would be, again,
Yeah.
it's people are waiting for conclusions from
Absolutely.
this
And
body. So thank you very much.
it is important to us. I will just say this. There, in all of these cases, there's a lot to take into account. And as I said in the prior hearing, we have seen assertions in cases where there were habeases and all kinds of legal proceedings, very similar to what we've seen here. And some of those folks were later proven to not be able to have committed the crime because of DNA. So one thing doesn't necessarily equal the other. What's disturbing to me is what it means to have had a system operate the way our system has operated. Because folks like the mother, Miss Gamble, who's come here, and whatever the truth is, in a sense, they have to rely upon what's already happened because they've built a life around that being closure for them. And that's problematic because we never had to have a system like this. And, you know, a lot of folks will talk about, well, this happened or that happened. One of the things that happened that we don't really talk about is that a body, in this case, this body, but across the country, a body like this, for a very long time, was not listening to the fact that though we invest a lot of trust into law enforcement hasn't always operated in the way that we have wanted / believed that they do. And so now we come to a space where we're dealing with the fallout of that. It's unfortunate. It's difficult. And folks are going to have to make decisions that are going to some folks seem like the wrong decision, but might actually be the right decision. That's the complexity of this issue. You know, it's not easy, I don't think, on any side. And I will say this to the benefit of those who are hearing. When you came before us, folks made a big deal, rightfully, I think, about the way that you made the decision. And a lot of what was suggested was that if only you had given us evidence of your thinking. I disagree a little bit with the notion that what you did wasn't right, given the history of the Board of Pardons and Parole and the way that they have made people speak about whether they were innocent or guilty historically. One could reasonably make the assertions you made, but despite that, I think that you did what the committee actually asked you to do. And so I don't find that as problematic as some others. And I'm sure we have disagreements about things, but the committee said to you that the issue here is that you didn't independently find for yourself that you believed that Mr. Streeter deserved this. And so you went back and did that. So I think we have to take all of that into account. These are, to me, whatever happens. Mr. Streeter gets the money, he doesn't get the money. These are sad days because they're bigger than Mr. Streeter. They're bigger than any one individual. They talk about who we value versus who we don't. They talk about who we listen to versus who we do not. It's part of what makes this job so difficult. It's also part of what makes this job so important. Further question or conversation? Further question or conversation from members of the committee? If not, thank you very much for joining us this morning.
Thank you, everyone. I appreciate the opportunity as always.
Okay. With that, I believe that is the end of our public hearing. So we are going to transition into the committee hearing portion of today. You give us 1 second. Okay. Madam Administrator, let me know when you're ready to go. Okay, we are going to convene the committee hearing for today, Friday, April 24th, 2026. Are there any remarks, comments? Not, you'll find yourself under Roman numeral number 3 on our agenda, which is a review of compensation award for wrongful incarceration. Number 1, Review of the Claims Commissioner's compensation award to Maceo Streeter with respect to his claim against the state for wrongful incarceration. Is there a motion?
So moved.
Moved by Representative Fasino. Is there a second? Yeah, I'll second it.
I second.
Oh, thank you. Seconded by Senator Gaston. Is there discussion? Senator Kissel. Sorry.
Thank you. And I heard Representative Fishbein being very kind to defer to me. I listened intently to the discussion that just took place this morning, and having reviewed the record both times. And while I have the utmost faith and confidence in Commissioner Shea and his analysis, in my humble opinion, the evidence just doesn't rise to the level of substantial. And to the extent Representative Fishbein pointed out, that language in the underlying bill, to my mind, substantial is a large burden, and there's conflicting evidence here, and I feel very badly for this individual if indeed he is innocent, but I don't feel that the evidence is substantial enough for me to support the award, and for that reason, I'll be voting no. Thank you, Mr. Chair.
Further questions, comments from committee members? Representative Fishbein.
Thank you, Mr. Chairman. As I said before, I find myself in a weird place. But I do concur with the statements that Senator Kissel made. It isn't preponderance and it isn't probable cause. It is clearly under the statute substantial evidence. So when I look at the evidence, I look at the items, I look at the law that the Claims Commissioner gives us. He takes the standard of substantial evidence, and the case that he cites is CF Cray v. Hadley, 47 Connecticut, 47 Con. 451. It's a 1998 case. And it says using this standard, so it's a substantial evidence standard as a backdrop, will give deference to the probate court's determination of the credibility of the witnesses and its factual determinations. And at each step, each level, the court found credibility. If it was a question at that point, the Claims Commissioner certainly could have asked to hear from those witnesses to assess their credibility, to reassess their credibility, to make a determination whether or not their post-conviction recanting, which not all of them really recanted because this Cheeks thing is up in the air, this purported affidavit, and she never testified and all this stuff. It is murky. But ultimately, does it rise to substantial evidence? I don't even think it meets the preponderance of the evidence standard. Does it tip the scale 51%? It's a long time. And we have the malfeasance by the New Haven police officer, the detectives. We'll say it in the plural. You know, I think New Haven should be liable if there's anything here. But the easy place to go is the state. Is that the proper process? And should my constituents be paying for their malfeasance? The answer has to be no there. But ultimately, what all that's before us here today is whether or not what the Claims Commissioner heard, took in, is substantial evidence of innocence. And I just don't see it at this time. So thank you, Mr. Chairman.
Thank you, Representative. Further comment or question from members of the committee? Further comment or question? Representative O'Day.
Thank you very much, Mr. Chair. I apologize for not being there. Didn't get home until about 2. I had to wait and charge my car on the way home from the House session. So I'm sorry I'm not up there.
Completely understandable, Representative.
and a little under the weather. But I just want to align myself with the remarks of the ranking members. I have the utmost respect for the claims commissioner. I think he's harder on himself than anyone else's. And I do think he's doing a good job. I'm going to listen to the discussion a little bit, but I have the same concerns that the good ranking members do on this one. But I appreciate the hard work this claims commissioner has gotten done and is doing. And so if I do end up voting no on it, I want to make sure the record's clear that I have not lost any faith in the claims commissioner, and I appreciate all the hard work he's done. But this one is problematic to me. So thank you very much, Mr. Chair.
And thank you, Representative Odette. Representative Dubitsky.
Thank you, Mr. Chairman. I have a question about the level of evidence that is required. Substantial evidence, is there a something in the law that establishes where on the scale substantial is? Whether it is more or less than a preponderance, whether it is getting close to clear and convincing, or whether it's just more than probable cause or something lower. I'm not exactly sure where on that scale substantial falls. Is there something that that we could be given that give us some indication of where it is?
Thank you for the question. I see Representative Bazzino is asked to respond.
Thank you, Mr. Chair. Thank you to the good representative for the question. So it's a flexible standard is how I would characterize it. It is, in my mind, based on the decision that the claims commissioner cites, which is Prelo versus CHRO 2009 case. Substantial evidence is satisfied if the record provides substantial basis of fact from which the fact at issue can be reasonably inferred. So in my mind, that is a standard that yields a reasonable inference of a fact. So maybe a little bit, I think a little bit more than what a preponderance of the evidence is, which is a fact is more likely to exist than not. In my mind, I see it as a little bit less than clear and convincing evidence, which is a standard that shows that a fact is substantially likely to occur. So I think, when I read that decision of, facts that yield a substantial inference, I take that to mean a little bit different than clear and convincing evidence. And when I look at the totality of the evidence that the claims commissioner's office reviewed in making this decision, I think that could lead to a reasonable inference that there is substantial evidence of innocence in this case. So all that to say, I think the standard is flexible. I think it gives some room to for reasonable minds to make an inference of the existence of a fact. But I think it's designed to be a flexible standard. Through you, Mr. Chair.
Thank you, Representative. Further comment or question from members of the committee? Further comment or question from members of the committee? If not, Madam Administrator, please call the roll.
Roll call vote. The motion is to confirm the claims commissioner's recommended compensation award for wrongful incarceration.
Let me just clarify something really quickly, because there was, and I'm sorry to cut you off, Madam Administrator, but I just want to make sure there's no question. There was a question on whether or not I clarified the motion. The motion that I asked for a motion and a second on was, as you were about to say, to confirm the claims commissioner's recommended compensation award for wrongful incarceration to Maceo Streeter. You may proceed.
Roll call vote. Winfield,
In the affirmative.
Staffstrom,
Staffstrom votes yes.
Flexer, Gadkar Wilcox,
Senator Gadkar Wilcox votes yes.
Fazzino,
Bazzino votes yes.
Kissel, Fishbein,
No.
Blumenthal, Brown, Cabrera, Callahan,
Callahan, no.
Chicarella, DiCaprio, Delaney, Dillon, Doucette.
Doucette votes yes.
Thank you. Delaney.
Madam Administrator, Representative Delaney votes yes.
Thank you. Dubitsky,
Yes.
Elliott, Gaston, Gilchrist, Godfrey,
Godfrey votes yes.
Howard, Jacobson.
Howard, no. Sorry, Kirsten, Howard, no.
Thank you. Jacobson, Johnson,
Representative Johnson votes yes.
Khan, Lamarck Muir,
Yes.
Lesser, Marr,
Senator Marr votes yes.
Miller, O'Day,
Day votes no.
Osborne, Pavlik Tomato,
Pavlik Tomato votes no.
Perillo, Quinn, Rahman, Roberts, Retigliano,
Retigliano votes no.
Sims, Veach,
No.
Walker, Wilson,
Wilson votes yes.
Thank you very much, Madam Administrator. Next, we'll find ourselves under Roman numeral number 4, bills for,
Are
yes,
we going to be holding votes up?
yes, we will be holding votes. I was going to say that later, but I'll say it now. We will hold votes until 3. Item number 4, bills for consideration from the House and the Senate. Substitute number 2, substitute for Senate Bill number 116, an act concerning the prevention of human trafficking. Is there a motion?
So moved.
Second.
Moved by Representative Fazzino, seconded by Senator Kissel. Is there discussion? Is there discussion on this item? If not, Madam Administrator, please call the roll.
roll call vote on Senate Bill 116 to JF it to the floor. Winfield,
Winfield, in the affirmative.
Staffstrom,
Staffstrom, yes.
Flexer, Gadkar Wilcox,
Senator Gadkar Wilcox votes yes.
Fazzino, Kissel, Fishbein, Blumenthal,
Blumenthal votes yes.
Brown, Cabrera, Callahan,
Callahan, yes.
Chicarella, DiCaprio, Delaney,
Delaney votes yes.
Dillon, Doucette,
Doucette, yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey,
Godfrey votes yes.
Howard,
Howard, yes.
Jacobson, Johnson,
Rep. Johnson votes yes.
Khan, Lamarck Muir,
Yes.
Lesser, Marr,
Marr votes yes.
Miller, O'Day,
Day votes yes.
Osborne, Pavlik Tomato,
Pavlik Tomato votes yes.
Perillo, Quinn, Rahman, Roberts, Retigliano,
Yes.
Sims, Veach,
Veach votes yes.
Walker, Wilson.
Wilson votes yes.
Lesser, yes.
Thank you, Madam Administrator. Now we are on number 3 under Roman numeral number 4, Senate Bill number 342, an act concerning health coverage as amended by Amendment A in the Senate. Is there a motion?
So moved.
Moved by Senator Lesser, seconded by Representative Fazzino. Is there discussion? Is there discussion on this item? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 342 to JF it to the floor. Winfield,
Winfield in the affirmative.
Staffstrom, Flexer.
Staffstrom, yes. Staffstrom, yes.
Thank you. Flexer, Gadkar Wilcox,
Senator Gadkar Wilcox says yes.
Fazzino, Kissel, Fishbein, Blumenthal,
Blumenthal votes yes.
Brown, Cabrera, Callahan,
Callahan, no.
Chigarella, DiCaprio, Delaney,
Delaney votes yes.
Dillon, Doucette, Dubitsky,
No.
Elliott, Gaston,
Gaston votes yes.
Gilchrist, Godfrey,
Godfrey votes yes.
Howard,
Howard, no.
Jacobson, Johnson,
Representative Johnson votes yes.
Khan, Lamarck Muir,
Yes.
Lesser,
Lesser, yes.
Mar,
Mar votes yes.
Miller, O'Day,
Day, no.
Osborne, Pavlock Tomato,
Pavlock Tomato votes no.
Perillo, Quinn, Rahman, Roberts, Ritigliano,
No.
Sims, Veach,
Beach votes no.
Walker, Wilson.
Wilson votes yes.
Doucette votes yes.
Thank you.
Thank you. We are now going to move to item 4 on today's agenda, substitute for Senate Bill number 457, an act concerning the state's bottle bill as amended by Senate Amendment Schedule A. Do we have a second? I'll second it. Seconded by so moved by Senator Kissel, seconded by Representative Fazzino. Is there discussion? Senator Kissel.
Thank you, Mr. Chair. I want to thank Attorney Melanie Dykes for pointing out in the Senate that there does seem to be some work needed on the gradation of the penalties. It starts with certain levels and then says above that. And so there seems to be a cascading effect and making it less clear than it could very easily be if it was just worded differently. We don't have the ability to make an amendment here since it's already been amended on the floor of the Senate. So I'm hoping that the powers that be hear this, but I certainly will be following it when it goes back to the Senate to try to remedy that portion of the bill that can so easily be fixed. Thank you, Mr. Chair.
Thank you to the good ranking member. Further discussion from committee members? Seeing none, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 457, the JF to the floor as amended by Senate Amendment Schedule A. Winfield, Staffstrom,
Yes.
Flexer, Gadkar Wilcox,
Senator Gadkar Wilcox is yes.
Fazzino,
Yes.
Kissel, Fishbein, Blumenthal, Brown, Cabrera, Callahan,
Callahan, yes.
Chicarella, DiCaprio, Delaney,
Delaney votes yes.
Dillon, Doucette,
Doucette, yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
thank you, Gilchrist, Godfrey,
Godfrey votes yes.
Howard,
Howard, yes.
Jacobson, Johnson,
Rep. Johnson votes yes.
Khan, Lamarck Muir,
Yes.
Lesser,
Yes.
Mar,
Mar votes yes.
Miller, O'Day,
Day votes yes.
Osborne, Pavlock Tomato,
Pavlock Tomato votes yes.
Perillo, Quinn, Rahman, Roberts, Ritigliano,
Yes.
Sims, Veach,
Beach votes yes.
Walker, Wilson,
Wilson votes yes.
Winfield in the affirmative.
thank you,
And Madam Administrator, Blumenthal in the affirmative as well. Thank you.
thank you.
Thank you. We now move to item 5 on section 4 of today's agenda, substitute for Senate Bill number 481, an act concerning nursing home ownership transparency, financial safeguards, protecting nursing home operations and property, and prohibiting required arbitration agreements. I believe we have discussed an amendment on this. We are proposing an amendment to strike subsection C of of section 1, lines 38 through 44. Oh, sorry. Yeah, let's move and second the bill first. Is there a motion on the underlying bill? Is there a motion on the underlying bill?
So move, Godfrey.
Moved by Representative Godfrey,
Seconded.
seconded by Representative Staffstrom. Thank you. So, as discussed, we are in possession of an amendment to strike subsection C of section 1, lines 38 through 44. Is there a motion? Moved by Senator Kissel. Is there a second? Seconded by Representative Fishbein. Is there discussion?
Mr. Chair,
Yes.
Mr. Chair, just for the information of the committee, for today, we're going to consider this friendly.
Thank you, Mr. Chair. Further discussion on the amendment? If not, let me try your minds. All those in favor, please signify by saying aye.
Aye. Aye.
Those opposed, nay. The ayes have it. The amendment is adopted. Further discussion on the underlying bill? Seeing none, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 481 to JFS it to the floor with Amendment A. Winfield,
Winfield, in the affirmative.
Staffstrom,
Staffstrom, yes.
Flexer, Gadkar Wilcox,
Senator Gadkar Wilcox is yes.
Pizzino,
Yes.
Kissel,
No.
Fishbein,
No.
Blumenthal, Brown, Cabrera, Callahan,
Callahan, no.
Ciccarella, DiCaprio, Delaney,
Representative Delaney in the affirmative.
Dillon, Doucette,
Doucette, yes.
Ubitsky,
No.
Elliott, Gaston, Senator Gaston,
Yes. Senator Gaston votes yes.
Gilchrist, Godfrey,
Godfrey votes yes.
Howard,
Howard, no.
Jacobson, Johnson,
Representative Johnson votes yes.
Khan, Lamarck Muir,
Yes.
of care.
Lesser, Mar,
Mar votes yes.
Miller, O'Day,
O'Day votes no.
Osborne, Havelock Tomato,
Havelock Tomato votes yes.
Perillo, Quinn, Rahman, Roberts, Retigliano,
No.
Sims, Beach,
No.
Walker, Wilson,
Wilson votes yes.
Lesser, yes.
Thank you. The votes will be held open until 3 p.m. Until then, we will go into recess until 3 p.m. Thank you.
Okay. Representative Delaney, can you guys hear me okay?
Yes, Madam Administrator, I just want to make sure that I'm not recorded as having missed anything.
You're all set, Representative.
Thank you, Madam Administrator. Have a good day.
Okay, take care. Have a good weekend. Representative Johnson?
How you doing, Kirsten? Similar
Good, myself.
situation. Good.
Just make sure.
Some pictures later.
Yep, you're all set.
Thank you. Have a great weekend. Appreciate
You
you.
too.
Thanks.
Senator Gaston?
Yes, similar situation. Just want to make sure that I didn't miss anything because my volume has been acting up a little bit today.
No worries. No, So for the first, I need you for the wrongful incarceration, the award.
Absolutely, yes.
Okay, and then. That was it. Yep, you're all set.
Thank you.
Thank you. Senator Marr?
Same thing.
All right, so. You're all set? Have a good
Okay,
weekend.
Kirsten, have a good weekend. Thank
Okay.
you.
Senator Cabrera?
Hi, how are you?
Good, and yourself?
I'm well.
All right, so top of the agenda, the Claims Commissioner, the award for the wrongful incarceration. How would you like to vote?
Senator Cabrera votes yes.
Okay, for Senate Bill 116,
Senator Cabrera votes yes.
for Senate Bill 342,
Senator Cabrera votes yes.
for Senate Bill 457,
Senator Cabrera votes yes.
and for Senate Bill 481.
Senator Cabrera votes yes.
All right, you're all set. Have a good weekend.
Thank you. Have a great weekend.
Representative Osborne.
If there's anyone on right now, do you want to circle to them first or?
Representative Dillon's on, but I haven't. It's just you and her. So if you need a second, just let me know when you're set. Yep.
Hello, Rep. Osborne.
All right. Let's tap the agenda for the wrongful incarceration award.
Rep. Osborne votes yes.
Okay, for Senate Bill 116,
Osborne votes yes.
for Senate Bill 342,
Osborne votes yes.
for 457,
Osborne votes yes.
and for 481.
Osborne votes yes.
You're all set. Have a good weekend.
Thanks, you too. Bye.
Representative Gonzalez, I think you are all set as well.
Okay, thank you. Have a nice weekend.
Hey, Representative Dillon.
Representative Pavlak D'Amato, House Bill 5036.
What was the title of that one?
Yep, it's an act streamlining residential solar permitting and energy infrastructure.
Representative Dillon.
Let me come back to that.
That's okay.
Thank you.
And I don't see anybody else on.
Hi, Representative Brown.
Hi, Kristen.
How are you?
Fan freaking tastic.
It's Friday.
Yes.
Top of the agenda for the Claims Commissioner Award. How would you like to vote?
Yes.
Okay. Senate Bill 116,
Yes.
342,
Yes.
457,
Yes.
and 481.
Yes.
All right, you're all set. Thank you.
Thank you, Kirsten. Have a good weekend.
You too.
Hi,
Hi,
hello.
Representative. Oh, Senator.
Am I bumping? Oh, I'm sorry, Senator.
No, go ahead.
Representative Dillon, there you go. Oh, for at the first for the wrongful incarceration award, how would you like to vote?
I'm sorry, I can't hear you.
Is my mic can you hear me okay? Representative, can you hear me?
Go ahead.
Can you hear me, Representative Dillon?
I can, but not the video isn't working, which has been the problem all day. But
Oh, okay.
can you see me?
I can't see you. I know the video's on it. I can't see you.
Yeah, my video keeps going on and off. I don't understand it.
That's okay. How would you like to vote for the wrongful incarceration award?
Yes,
Okay, for Senate Bill 116,
yes,
Senate Bill 342,
yes.
457,
Yes,
and 481.
yes.
Okay, you're all set.
Thank you.
You're welcome. Senator Miller, give me just one quick second.
So I'm done, yes?
You're all set, Representative Dillon.
Thank
Yep.
you, ma'am. And
Thank
we'll
you.
have
Have
to
a good
get
weekend.
IT again on the video. Okay.
Good luck. Senator Miller?
I'm here.
Okay, great. I want to pull up the agenda. So for the wrongful incarceration award, how would you like to vote?
Yes.
Okay. For Senate Bill 116. That is.
Yes. Yes.
All right, for Senate Bill 342,
Yes.
Senate Bill 457.
Yes.
And then for this last, for 481, there was an amendment to strike section 1, subsection C. It was lines 38 to 42, or 38 to 44, rather.
I didn't see that. So I looked at the original. So do you remember? Remove them?
What the language change was?
Oh.
And your audios.
I just loaded it.
And your audio.
Yeah. Can you hear me?
I can now. Yep.
Okay. So yes.
Okay. Yes on that. All right, then you're all set.
Thank you. Enjoy
Have
your
a good weekend.
weekend.
Thanks.
Bye-bye.
Representative DiCaprio, if you're there.
I am here.
Excellent. So top of the agenda for the Claims Commissioner Award, how would you like to vote?
Okay, there's 5 items, is that right?
That's correct. Yep. We have the award, and then we have 4 Senate referrals.
Okay. Number 1 would be a no.
Okay. And then for Senate Bill 116.
Item number 2 is a yes.
Okay. Number 3.
Would be a no.
Number 4.
No.
And number 5.
No.
All right. You're all set.
All right, thank you.
Have a good weekend.
You too.
Representative Roberts.
Word.
All righty. Top of the agenda, the wrongful incarceration award, that claim. How would you like to vote?
Yes.
For Senate Bill 116,
Yes.
342,
Any day you want.
Yes.
Make sure you cancel it.
457,
Oh, they're gonna charge you $30. You know what?
Yes.
I found out
and then for 481.
for downtown, if you
Yes.
take $3.99 a month.
You're all set.
Thank you so much.
Unlimited.
Thank you. Hi, Representative.
Hi, how are you?
Good, and yourself?
Doing well.
Top, okay, for the award. Awesome. I have you for everything.
Oh, good. Thank you.
You're all set. Have a good weekend.
You too. Bye.
Hi, Representative.
Sorry, I used to do it on my phone. Happy Friday.
You do.
I would like to vote yes on everything, please. Thank you.
Okay, you're all set.
Have a good weekend.
You too. Hi, Senator. Let me know when you're ready to vote.
No.
You all set?
Hi, sorry, I couldn't hear you.
Oh, that's okay. Can you hear me okay now?
Yes, yes,
All
yes.
right, perfect. Top of the agenda, we have the Claims Commissioner Award for wrongful incarceration. How would you like to vote?
So tell me first, our chair, Senator Winfield, if he's voted all yes,
Yes, he voted yes for everything.
everything okay, let's
Yep.
do it then.
So for the award, how would you like to vote?
Yes,
Okay. 116 for Senate Bill 116.
yes,
Okay. 342,
yes,
457,
yes,
and then 481.
yes.
Okay, you're all set. Thank you.
Awesome. Thank you.
Have a good weekend.
You too.
Hi, Representative.
Hey, Kirsten, how are you?
Good in yourself.
Good, thanks. Good, thanks.
All right, so how would you like to vote for the wrongful incarceration award?
Yes,
Okay, and then for the Senate referral, Senate Bill 116,
yes,
342,
yes,
457,
yes,
and 481.
yes.
You're all set. Have a good weekend.
Thank you, you too. Bye.
Hello.
Good morning. Oh, no, afternoon.
Good afternoon.
Got me. It got me.
What day is it? What time is it?
Oh my gosh. All right. So today's agenda for the wrongful incarceration award, how would you like to vote?
Yes.
Okay. For Senate Bill 116,
Yes.
342,
Yes.
457.
Okay, wait, actually, hold on one second. Let me. I was looking at, I thought there was only one agenda, so hold on a sec. Let me.
Yeah, we had one award and then there was four.
Committee meeting agenda. Okay. Okay, shopping coverage.
This is 457.
So 457 is a yes, and then
Okay, 41.
41 is a yes as well. Thank you.
All right.
Thanks.
Thank you
giving
so
me-
much.
All right, have a good one.
You too.
Bye.
Senator Flexer,
Hi, how are you?
good and yourself.
I'm good.
For the wrongful incarceration award, how would you like to vote?
Yes.
For 116,
Yes.
342,
Yes.
457,
Yes.
and 481.
Yes.
All right. Thank you so much.
Thank you. Have a good
Have a good
weekend.
weekend. Hi, Senator.
Good afternoon.
How are you?
Pretty good.
For the wrongful incarceration award, how would you like to vote?
No.
For Senate Bill 116,
Yes.
342,
No.
457,
Yes.
and then 481.
No.
All right, you're all set.
Thanks a lot.
Have a good weekend.
You too.
Hi, Representative.
Hello, Madam Administrator.
All right,
I
so
think I missed one vote.
I think you did. For the award, how would you like to vote?
One moment. I'm assuming the chair voted yes.
He did. They both did.
I'm a yes.
Okay, and then I need you for one more. For Senate Bill 481, the last one we amended it, we took out 4 lines.
What was the title of that bill again?
1 second. 481 was requiring nursing home ownership transparency, financial safeguards, protecting nursing home operations and property, and prohibiting required arbitration agreements.
I'm a yes.
All right, you're all set. Thank
Thank you
you.
very much. Have a good weekend.
Hi, Senator.
Hey, how are you?
Good, and yourself?
Good, good.
All right, so for the wrongful incarceration award, how would you like to vote?
I'm gonna recuse myself from that.
Okay, and then for Senate, for the referrals, for Senate Bill 116,
That's the human trafficking. Yes.
Yep.
Yeah.
for 342, health coverage.
No,
Okay, for 457, which is the bottle bill.
no,
And then for 481, it was amended. We stripped out 38 to 44, and then
yeah.
and that's it.
No,
It's nursing home. one.
that's no.
Okay. Right, you're good.
Thank you so much. Have a great weekend.
You too. Take care. Hi, Representative.
Hello, Kristen. How are you?
Good. So we've got the one award and then the 4 referrals. How would you like to vote on the award?
On the award, I'm in the affirmative.
Okay, for Senate Bill 116,
In the affirmative.
for 342,
In the affirmative.
for 457,
In the affirmative.
and then for 481.
In the affirmative.
Okay, you're all set.
Awesome. Thank you so much.
Have a good weekend.
Have a great weekend. Bye-bye.
Hi, Representative. Let me know when you have a sec, or when you're ready to vote.
Oh, I'm sorry. Yes, I'm ready.
All right. So we had the one claims commissioner award and then the 4 Senate referrals. So for the award, how would you like to vote?
Yes.
Okay. For Senate Bill 116, how would you like to vote?
Yes.
For 342?
Yes.
For 457?
Can I skip this one for now?
Yeah,
And
of
go
course.
to
And
five?
then 481?
Yes.
Okay, that's it.
So for number 4, when are
Yeah.
you open till? When are you guys doing votes till 3 o'clock?
Yeah, till 3.
Okay, let me call back.
Yeah,
Okay.
no worries. Yeah.
Thanks.
Yeah. Hi, Representative.
Hey, okay, on the bottle bill, I'm gonna be a no.
All right, awesome. You're all set. Have a good weekend.
Thank you, you too.
Hello.
How are you?
I'm doing great. You give me like 3 seconds.
Yeah, absolutely.
I figure you're in a big rush.
Yeah.
Yeah. All right. Okay.
All right, so
I'm
we
ready
have,
for you.
we've got the wrongful incarceration award, and then we have 4 Senate referrals. So for the award, how would you like to vote?
Yes.
Okay. For Senate Bill 116,
Yes.
342,
Yes.
457,
Yes.
and then 481.
Yes.
All right, that's it. You're all
Thank
set.
you.
Have a good weekend.
You too.